Welcome to Tangents from Coin Center. I'm Jerry Brito, and with me, as always, is Peter Van Valkenburg, our Director of Research. Hi, Peter.
Hi, Jerry.
So we're doing this thing again. Tangents is kind of our on again, off again podcast, but
Backed by popular demand. I think
quite,
we got no fewer than 2 emails over the course of the last 6 months saying, "What happened to tangents?"
But if you weight those, that's probably thousands of people who've been
I think
asking.
it's true. Yeah.
Yeah.
And they're cool. They're cool people.
Yeah. So we're probably going to try to pick this up again, and just sort of talk about policy and law and crypto. And today's topic is going to be stable coins. And it's an issue that I've been getting a lot of questions about. So I thought we'd record a little something and talk about it. We're getting a lot of questions because, as everybody knows, the President's Working Group on Financial Markets, which is essentially a interagency working group of all of the different financial regulators, so SEC, CFTC, Treasury, OCC, CFPB, all of those good guys make up this working group, and they are tasked from time to time with coming up with reports to study an issue and come out with a comprehensive report with recommendations.
Can I ask a question?
Yeah.
For the clarity of our audience, are they the FSOC?
No.
No.
They are not the FSOC. That's the Financial Stability Oversight Council.
Right.
So
but the FSOC's been interested in stablecoins too, right?
They have. And we had understood that the FSOC had been working on a stablecoins report that never materialized. And we believe at this point has been shelved. And that was done under the
got picked up by the President's Working Group.
I don't think it's the same report because yes, exactly. Yes.
Like they can't crib from each other.
Maybe they could. I'm sure that the draft report from the FSOC is available to these folks. But it's a good point, Peter, because this is an interesting or an important distinction. The FSOC actually has policymaking authority. The FSOC is a council created by Dodd-Frank, and it can vote to designate certain actors or types of things as systemically important. Yes. And if you're so designated, there are all kinds of rules that are triggered that apply to you.
And I'm not an expert in Dodd-Frank, but when I looked at that, and I know this is a tangent to our tangent already, but there aren't even rules that apply to you per se. There's sort of the freedom to write whatever rules should apply to you that can be assigned to like the Fed. So looking at Dodd-Frank, like if you're designated as systemically important, you might not be traditionally regulated as like a financial service, but suddenly you are. And according to what rules? Rules that we will now write, knowing that you're systemically important. It's
correct.
It's interesting. Anyway, that's a tangent.
Yeah, that's because you are a Gorsuch groupie and care about delegation.
About the non-delegation doctrine, which says that only Congress should make rules. Well, laws, but rules are laws. Anyway.
Okay, but coming back up, the President's Working Group, on the other hand, is not a policymaking body. Right? It is merely a talk shop. It is a working group, and they will put out a report with potentially recommendations, and then some other policymaking body like the SEC or the FSOC, can decide to implement those or not. So we'll get a report, but whatever the report says won't be binding. It'll just be, recommendations.
Right. So when people see headlines that say like imminent new stuff coming, it's like, well, it's a report.
It's a report.
It's only so imminent.
Yeah, it's pretty serious though, right? But okay, so the President's Working Group has been working on this report for some time, and we keep hearing that its release is imminent. They have been late consulting with folks in the industry and in the public, and have been having a series of meetings. We participated in one of these. Essentially, the way it works is, you're invited to present for 5 minutes about what you think about stablecoins, along with maybe 5 or 6 other firms or interest groups.
And then they tell you why you're wrong.
Well, they don't say anything really.
No, they don't actually say anything.
They don't say anything, and they barely ask any questions, and that's it. That's kind of all the input that you get. So, with that in mind, the fact that this report is coming down, we'll be getting a lot of questions. And Gary Gensler, the chairman of the SEC, has been talking about stablecoins a bit, most recently in testimony. And we thought we'd say something about it. And off the top, what I want to say is something that I told the President's Working Group when we briefly had the opportunity to talk to them, is that stablecoins are not cryptocurrencies, right? They are an application of cryptocurrency networks that are anchored to the regulated financial system, right?
And email is not the internet.
Well, yeah, but it's even more than that, right? They're not stablecoins. Not only do they run on top of cryptocurrency networks, they require, and again, we're not talking about algorithmic stablecoins here, guys. That's a whole different podcast. We'll do that some other time. We're talking only about backed stablecoins in this podcast, and they're going to be backed by some firm that is tied to the financial system, right? They're going to be a traditional financial institution in some respect, right? There's going to be issuing these, and so as a result, the policy questions surrounding stablecoins are generally outside the core focus of Coin Center's research and advocacy. So this is why you don't hear us talking about stablecoins very much. This is why you don't hear us talking about crypto ETFs very much, because they're not really about cryptocurrency itself. They're about a financial product by a traditional financial institution that happens to be tied to that. But we have relevant expertise and we get asked a lot. So here we
And
are.
that there are limits to that
Yeah.
that claim that it's outside of our realm. Like
Oh yeah, yeah. It's very fun.
when the Stable Act came out, we don't have too much to say. This is a good example. We don't have too much to say about some things in that act. Like there was a proposal that maybe only FDIC insured and federally regulated banks should issue stablecoins. That would not be within Coin Center's mission to have an opinion on that.
Right.
Where we had a problem with the Stable Act was not how you issue stablecoins. It was the assertion in the law and the bill.
It wasn't. By the way, it wasn't even a bill. It was just a discussion draft of a bill. Draft. Yeah.
So the assertion in the discussion draft was a passage that said if you are facilitating or passing stablecoins that are not issued by a federally regulated bank, then you can be held liable for a violation of the act. And you could interpret that language to mean that merely validating the Ethereum blockchain, which has all these potentially unpermitted stablecoins traveling on them, even just validating as a node would violate the law. And that's when it becomes relevant to Coin Center, because these networks are purpose agnostic. They're infrastructure, they're public goods. We just want them to be available, and the things that threaten them are within our core mission.
Right. There's a fuzzy line. There's a balancing test, if you will. But I think people get the idea of what we work on and what we generally don't. And what else was I going to say? Oh,
it's like if they would like pornographic NFTs were banned. We would be like, we don't have a position on pornography, but you can't make people liable for running a blockchain that has porn on it.
Okay, thank you for that, Peter.
I just wanted to bring up. I'm keeping it spicy, Jerry.
Also, just to say that that's to say that Coin Center isn't going to have an institutional position, and we're not going to work on it, do research or advocacy really on these things. But that's not to say that you or I don't have opinions on these things, and we might share those if we want. Okay, so I want to talk about the regulation of stablecoins, which the working group report is going to touch on, and then also the systemic risk issue that keeps coming up. So first on the regulation, Gary Gensler, a week ago? Gosh, it feels like forever, but like a week ago, he testified before the House Financial Services Committee, and he said that there's basically a spectrum of stablecoins. On one end of the spectrum, you've got sort of somebody who is issuing an asset that is backed by a pool of other assets, often securities. And at the other end of the spectrum, you got what he called kind of like wrapped fiat. And he basically said that at one end of the spectrum sure looks like a security, and at the other end of the spectrum probably isn't. Of course, he didn't use that language. I don't mean to put words in his mouth, but I've got his whole testimony here. I could read it for you. But essentially, that's what I take away from what he said, and I think that is pretty much right. Right, under existing law. I'm not saying whether it should be this way or shouldn't be this way. I'm saying that's, I think, a pretty accurate interpretation of the law that is pretty uncontroversial. Certainly, as to the ends of these things, I think in the middle is where it gets a little dicey, and we'll talk about that. What do you think about that so far?
Yeah,
I'm
I
good.
think I think that's right.
Yeah.
But the middle is really hard, right?
Okay. Well, let's
And
get to. Go ahead.
Get to the middle.
Well, okay. So let me keep going. Peter has no idea what I'm going to say because I wrote a little outline for this. Okay. So on one end, you have stable coins that are issued by a company that is not licensed or chartered by any prudential regulator, right? And it invests its deposits in commercial paper or other securities. Now, Peter, would you say that this is clearly a security? Not under the Howey test necessarily, right? Because I think people will often say, well, there's no expectation of profits when it comes to a stable coin. How would you analyze that?
So you can so it's interesting. So I sense you want me to bring up Reeves.
No, I don't, but keep going.
but we could. You don't need to get there though. So there's just a little background. Again, what a security is defined in law in the 33 Act and includes a lot of things. Among them, the things that we would expect, like debt, bonds, these sorts of things, but also notes and investment contracts. And those two terms,
this is literally a comma-separated list of things. It says debt, bond, notes. Okay, sorry.
Notes, investment contracts.
Investment
and I guess there hasn't been as much disagreement about what some of those things mean, like a bond. It's debt from a corporation with a promised rate of return, things like that. But notes and investment contracts are very vague terms, and so courts ended up defining them. And investment contract was first the definition of investment contract was first sort of solidified in the 1950s in the case that we talk about way too often here on Tangents and at Coin Center, the Howey case, W.J. Howey versus, is it the SEC or the U.S.? I don't know. I can't remember. And in that case, the court created a 4-part flexible test. Rather than having a totally clear black line, black letter law, there's this flexible test, which is investment of money with an expectation of profits dependent on, I'm going too fast. Investment of money in a common enterprise with an expectation of profits dependent on the efforts of a third-party promoter. And as you were saying, if we just look at the investment contract analysis with a stable coin, like immediately a light bulb pops up maybe to a lawyer who wants to say that this isn't a security and says, well, it's not a profits coin. It's a stable coin. It's deliberately marketed to say that you shouldn't expect profits. You should expect stability. And on the face, that's kind of reasonable. And yet there's some issues here. Lots of stable value funds traditionally have been regulated as securities. They tend to be Investment Act, 40 Act funds. So they went through a process which sort of predetermines that they're going to be securities because you started it and went through this process from the beginning with the SEC under a different chapter of the code. But at the same time, it also kind of makes sense that, what is stable? What is a stable value? It is going to be a speculative gamble on whether you can maintain parity with some purchasing power or with some other currency. So if there's discretion inherent in the process of maintaining the stable value, there is this risk capital, which is another part of the securities jurisprudence, that you're saying, I'm trusting this capital with you. I'm taking a risk that you'll do this thing, which is maintain a stable value, which is a profitable thing to have stable value in a world that could have inflationary currencies, or you could have been invested in assets that lose value, which is the same as inflationary currencies. But
and short of trusting a bank, which is regulated by a separate set of laws, right? So if you're saying I'm not a bank, But you can give me money, and I will invest it and manage it in such a way that it will retain its value. I mean, maybe there are no profits technically, but you still, as an issuer, are presenting all of the risks that the securities laws are there to guard against, right?
Right.
So I think it would make sense that something like Howard would apply, but we don't even have to get there because it could be a note too, right?
It could be a note too. And so this is that Reeves case, which is a whole nother matter. So note is a broad term that could mean a lot of things. And obviously banknotes aren't securities, right? Like actual banknotes, like when you take a piece of paper from a bank that the bank says has value. You could look at like Bank of Scotland notes. You could think of federal bank notes, which, banks deal in. Those clearly aren't securities because they don't go through the right disclosure regime. They don't only trade on the New York Stock Exchange. People trade banknotes person to person and, all these things. So
cashier's check, I imagine, would also fit this description.
Yeah. So courts had to basically say, all right, when they said note, they didn't mean like a bank note, but we needed a case about this because it just said note. And so there is this other test that the courts came up with in this Reeves case where they said, look, there's something called the family resemblance test. It's great how loosey-goosey a lot of securities law is. Although I actually think it sometimes is great because it means it's flexible. To like computer scientists who want determined variables, it's like a nightmare, but the law is often flexible for the right reasons. Anyway, so the family resemblance test says there's this family of things called notes. And some notes in this family, I think that's how they're using family. Anyway, some notes in this family are not traditionally treated as securities. Things like bank notes, things like commercial paper. And if your thing is a new thing, but resembles this family of notes that aren't traditionally thought of as securities, then it is also not a security. And that sounds very vague.
Now, wait a minute. Did you just say that commercial paper is not a security?
Short-term debt, I'm pretty sure is not a security for the purposes of the typical securities laws.
Okay.
Yeah. A bundle of a bunch of commercial paper that backs something else might be a security.
Okay.
But commercial paper is a short-term debt of one big company to another, and usually not dealing with retail investors, and usually. So I might be wrong. I'm glad you checked me on that. I might be wrong, but I'm fairly certain commercial paper is one of these things. And so the court said,
it's like a negotiable instrument.
Yeah, it's a negotiable instrument. Yeah. A note. And so the court said, all right, we can't just say if it resembles this family because that's vague. So we'll have a couple of different factors here. And one of the important factors, I think, that everything in this family generally has, and things that don't have this, therefore might not be in this family, and therefore might be securities, is the presence of some other regulatory regime that addresses the same information asymmetries and the same investor protection risks that would otherwise be addressed in securities regulation.
Right.
And so the courts say, look, if you are a chartered bank, for example, you've got heavy duty regulation. You've got either a state banking regulator who charters you and examines you yearly or quarterly, or you're a federal bank. We have an investor protection regime in place for the kind of, say, short-term debt that you issue. That means that short-term debt or that note that someone can, claim against you doesn't need to be regulated as a security. And so in your hypo, to get back to the beginning of this question, where this is not this is a completely unregulated entity. It's just a company that's maybe incorporated somewhere in the world that decided to say, give us some assets, we'll hold them for you, and you'll have this token, and we'll adjust the composition of the assets that back it to make sure it stays stable. If there's no regulatory regime in place, they're missing that aspect of the family resemblance test that says, is there another regulatory structure that addresses investor concerns? Right. And that could mean that under the Reeves test, this thing, even though it looks kind of like typical short-term debt, is a security because it's not actually like other notes that historically have been removed from the securities laws.
Right. And so, yeah, it's key to understand, we're talking here about a firm that is not regulated by any prudential regulator, right? Maybe this firm has registered with FinCEN so that it complies with anti-money laundering law, but that has nothing to do
Right.
with what we're talking about here, right? Which is either registering with the SEC as a security, and if not, getting some kind of charter or license that says
Right.
that you're prudentially regulated.
Prudential regulation.
Okay, so that's, as
Fairly clear cut.
fairly clear cut, it seems. As Chairman Gensler was saying, that's one end of the spectrum.
Yeah.
At the other end of the spectrum, you have stablecoins that, one, are issued by charter banks or trusts, and hold deposits in cash or cash equivalents, often in insured depository institutions, right? So here I'm thinking of something like Paxos Standard, right?
Yeah.
I guess it's called USDP now. How's is this a security? Do us the analysis.
Yeah. So this one's clear cut. Now you could say, well, the Howey test still applies, right? The Howey test didn't say anything about a regulated entity or things like that. But the fact of the matter is, there's a bunch of case law here. It's just sort of assumed, I think, that when a bank issues you something like a banknote, or gives you a loan or something, that's not a security. But it was challenged in a couple of cases. So I think it's Marine Bank is a case about a Mexican bank issued certificate of deposit. And so there's sort of a question there, like, oh, it's a CD, and CDs are not traditionally treated as securities because they're banks. But this is a bank from a foreign country. Is it therefore a security when it trades in the U.S.? And the answer was no. They're like, if it comes from a prudentially regulated institution, like a bank, it's traditionally not going to be a security. Now, there are limits to that. And these are some interesting limits in that there's this case called Gary Plastic, which actually comes up. There's a bunch of, I think, was it Director Hinman who wrote a speech when Gary met Howey?
Yeah,
Talking
Gary
about Gary Plastic.
Yeah.
Gary Plastic is this case where Merrill Lynch, Gary Plastic was the plaintiff. They were suing Merrill Lynch. Gary Plastic was just a company that had invested a lot of its money in Merrill Lynch's financial products. Merrill Lynch was taking CDs and reselling them, CDs from other banks, and reselling them to investors and saying, this is like a certificate of deposit where normally you'd be bound to the term of the CD, and that's why they give you a better rate. But we will always buy it back from you in the future, or create a marketplace where you could sell it to another one of our investors. And so you'll always have escape from this CD. And
they were selling the CD plus a promise.
Plus a promise. Yeah. And we'll also be the one to claim on the FDIC insurance if the issuer went bankrupt. And so they were promising some additional things, a liquid marketplace and other things. And the court said in this case, which was partially brought because Gary Plastic was, I think, being really carefully watching about the rates that they could get from Merrill Lynch CDs versus the rates they could have gotten from just a bank, and realized that Merrill Lynch was taking some profit. And so they were upset about that. The court said, actually, Gary Plastic, you're right. Merrill Lynch is in the wrong here. They're not just selling you CDs. They are selling you securities, because the CD may not be a security. Indeed, it is not, because it's bank issued product. But the CD plus a promise of returns or value or something in addition, like we will check in with the FDIC, we will buy it back from you if you need to get out of it sooner, that is, in combination, is a security. So, yeah.
Okay. So
there it is.
So there it is. So in the case of something like Paxos, like we were saying, it's hard to see how it's a security because it's being issued by a
New York State trust.
New York State chartered trust company. And by the way, I think Paxos also has an OCC federal charter of some kind.
I think you're right.
And the assets are being invested according to that regulation, and it's super safe.
So you could also go back to that Reeves test from before. It's maybe less apropos because at this point we're basically talking about a bank, although the trust bank distinction is something I don't know a lot about. So if someone looked askance at this and said, oh, that's a trust, not a bank, well, you could say, well, Reeves still applies And so it doesn't have to be a bank that issues this thing, but it does have to be some regulatory regime in place that substitutes the need for securities laws under the
Right.
Reeves test that makes this family resemblance like
Right.
things that
And
aren't securities.
trusts are as bank-like as you can get without being a bank, it seems to me.
So far as I know, I mean, there's lots of different, like trusts are ancient, right?
Yeah.
There's trust and estates law, and there's different trusts that can be, you know, a various control of the trustee and the executor.
Yeah,
I don't know.
this is a trust under New York banking law, right? But anyhow, the point is, one end of the spectrum, pretty clearly security. Other end of the spectrum, pretty clearly not a security.
Yeah.
So then we come to the middle, the gooey, fun middle that we wanted to get to.
It's an Oreo.
So in the middle, what we have are stable coins that are issued by state licensed money transmitters and that invest deposits in whatever state law allows, which can be all kinds of securities, actually.
It can be a lot of different things. And every state that licenses money transmitters has, not every state, some of them have similar standards, maybe set by the Conference of State Banking Supervisors. But on average, most states have very different standards as to what is safe enough for a money transmitter to invest their customers' money in, so-called permissible investment requirements.
Right. And so here we're talking about things like USDC, right? So what's the analysis here?
Basically, you have a really hard analysis, which is maybe why it hasn't been done, and maybe why then there's a very good faith reason why this is still an unknown area. It's not like this is an area people are taking advantage of or where someone's trying to do something wrong. It's just like, actually, this is hard legal analysis, because what you're asked to do by the previous court rulings is to say, all right, well, we're probably going to use Reeves here in the family resemblance test. We have no case with precedent about money transmitters as a regulatory form that could substitute for securities rules. Because that's the question. Again, that's one of the questions that the Reeves test is going to ask is what is there a regulatory form that could substitute for the securities rules? And, you know, we've had money transmitters for a long time. I'm pretty sure that a Western Union or a MoneyGram, if you honestly, if you went all the way back then.
I'm smiling because you're getting ahead of me, but go ahead.
Oh, interesting. Yeah, good. Faster.
Maybe I should share my outline with you before we do this, but this is more fun.
But I'm pretty sure if you went back to like a Western Union or a MoneyGram, when you go to them and you give them cash and they give you a money order to pay your utility bill with or something like that, you know, that's short-term debt of the issuer. That is a note, but is it the kind of note that's traditionally regulated as a security? I would say almost certainly no, because people used to take money orders out all the time, and there was never any debate about whether or not that was a violation of the securities laws. That's how a lot of people used to pay their bills. And it's not like MoneyGram was just registering each one with the SEC every time they created a new money order for a customer. It all seems kind of crazy to think that that would have been the rule back then. But at the same time, money transmitters back then were very different than money transmitters today. It starts changing with PayPal, where, you know, we're not really selling you paper money orders to pay your utilities bills anymore. We're going to help you do any payments online, and you might just want to keep a balance in your PayPal account with us for the duration because you tend to do most of your shopping online. So why not just keep a PayPal balance? And so now they're not just giving you temporary money orders that are worth a set amount to pay your utility bill. They're kind of doing banking, but that's a whole nother conversation. They're kind of holding maybe even a lot of money for you. Maybe you just get your direct deposit. I think you could probably get direct deposit to your PayPal account a while ago. You definitely can now. And there still wasn't at this point a case about that, though, where PayPal's like holding lots of money for you, basically giving you an IOU, and is that IOU a security? Then you fast forward to digital currencies, and now a lot of these digital currency exchanges who want to sell people Bitcoin and other things, they just want a regulatory regime to fit into, so they don't have like someone knocking on their door in the middle of the night, which is quite fair, and probably because they believe in protecting their customers too. And other financial, technology companies that started up to do internet payments got money transmission licenses. See PayPal, see Venmo. We'll just try and get the same licenses, and lo and behold, it's hard, but they do it. And now we have, companies like Coinbase and other, crypto exchanges that are, places where you can keep money either in the form of digital currency or in dollars that you might want to keep to trade on the platform. And ultimately, they also start trading these things called stablecoins, or even issuing these things called stablecoins, which is still kind of like a PayPal balance then, because it's still money that, if they're issuing you the stablecoin, it's still money that they're holding in permissible investments because they are a licensed money transmitter. But now it's a transferable balance or debt that they're allowing you to move around. You could argue PayPal
I don't
money.
see how that's any different from PayPal, right?
You and I have had this conversation before.
Yeah.
I mean, it was interesting, so maybe we can recreate it, but I can't remember what I said. I think I said something like, it's kind of a closed loop system with PayPal in the sense that you can only use your PayPal balance at places that accept PayPal. Whereas with USDC, you can send a USDC balance to any Ethereum address.
Sure, but I don't see how that distinction makes any difference. So number one, by virtue of somebody,
right? Yeah.
Well, by virtue of somebody saying, "Okay, send it to my address," they are now. You can consider Ethereum to be the closed loop system. I don't see I don't see, and I don't see why the distinction makes any difference for security.
I have trouble arguing with you on this because I always thought the closed loop exemption from a lot of things like typical money transmission licensing and other things makes very little sense.
It makes sense for things that it's an easy way to exclude things that aren't the main target of these regulations, like airline miles and in-game currencies,
video game currency. So if Blizzard says when people mine World of Warcraft gold, it's supposed to stay on our platform. We know that they're going to eBay and selling it for dollars, but we don't condone that. In fact, we don't allow that. It's against our terms.
It's not supposed to be part of the fun playing the game. You're supposed to mine it in order to have fun playing the game.
Which is so fun.
Yeah. So, okay, but let's go back. So let's do the analysis. The question is, so with Reeves, the first question is this being issued by, how does Reeves put it?
So is the issuer regulated under some other prudential or investor protection regulation type scheme that could substitute for the investor protection concerns of securities laws?
And so, one easy way to solve this is by saying, they are regulated under state money transmission licensing law.
Totally.
And, as you say, PayPal and Western Union have been regulated this way forever. And
I was explaining, MoneyGram and Western Union and PayPal by saying that, like, back then it was sort of a stretch to argue that those things were securities because people weren't using them in a transferable way as a speculative vehicle, et cetera, et cetera, et cetera. And so it's obvious why we didn't have case law back then. And that means we still don't have case law today. So I can point to Marine Bank and Gary Plastic to say that a CD or other bank issued product is definitely not a security. I can't point to a money transmitter issued product and say that's not security with authority because I can't point to a case.
And so I think that's absolutely right. And so what I find so interesting about this, what we're seeing now, where the president's working group I don't think it'll go as far as opining on whether it's a security or not, but it might punt it to the SEC to look into it. Certainly, you're seeing different people. I won't go as far as to interpret Gary Gensler's remarks this way, but you're seeing certain people, even some people in Congress, kind of state that state money transmission licensed stablecoins are securities, right? Or should be treated as securities, right? And so what's interesting about this is if because stablecoins have become this hot button issue, we can maybe at some other point discuss why they became this issue. But
Facebook.
What's that?
Facebook. Sorry, I have a thing in my throat.
So because it's getting all this attention, we may get to the point where the federal government is going to have to in some way pronounce that they're securities, and by doing so, they are going to be upending not just this little thing called stablecoins, but all dollar balance accounts offered to the public by state money transmitters. So Venmo, PayPal, Apple Pay, Google Pay, maybe even Starbucks, whatever, all of these things, how are they going to be able to distinguish between saying something like USDC is a security, but PayPal and Apple Pay are not. And what I was smiling about before is that I went and looked at PayPal's terms of service, where they explain what they do with your money. And I'm going to read to you from the terms of service. This is what they say. PayPal is not a bank and does not itself take deposits. You will not receive any interest on the funds held by PayPal. PayPal combines your PayPal funds with the PayPal funds of other PayPal users and invests those funds in liquid investments in accordance with state money transmitter laws. PayPal owns the interest or other earnings on these investments. Okay. And, when I'm looking at recent statements by former SEC Chairman Clayton, or even by Gary Gensler in his recent testimony, they compare stablecoins that have investments in pooled assets to money market funds. And so it's going to be very interesting to me to see if they indeed choose to say that state money transmission licensed issued stablecoins are securities, how they're going to be able to distinguish that from PayPal and everything else like that.
So I have an answer for how they'll distinguish it if they wanted to.
If they wanted to, go for it.
I've just given you one factor of the Reeves test that's particularly interesting to us because we've worked in money transmission licensing stuff with crypto stuff in the past, and it just seemed pertinent.
Yeah.
But it's just one factor of the Reeves test.
What else?
And unlike the Howey test, which is a 4-part test where you have to check all 4 boxes, or else it is not a security.
Yeah.
With the Reeves test, you can check 1 box or 3 or 2, and the court it's a totality of the circumstances, and the judge at the end of the day is going to look at all these circumstances and be like, this looks like that, or this looks like that. It's very arbitrary. And some of the other factors. So I'm just looking now right at the case law. If the note is exchanged to facilitate the purchase and sale of a minor asset or consumer good, to correct for the seller's cash flow difficulties, or to advance some other commercial or consumer purpose, on the other hand, the note is less sensibly described as a security. Less sensibly. It's less sensible, Jerry.
Okay.
So, I mean, what do people use PayPal for? To buy stuff. What do you use stablecoins for? It's part of a portfolio of crypto assets that you invest in. I'm just saying there's a distinction you could make right there. I'm not saying that's right, but it could be easy to distinguish between a simple PayPal balance.
An argument that you can make, right? I think what Circle would come back and say to you, they'd probably come to you with a long list of merchants that accept USDC for everyday purchases,
and that it's mostly for everyday purchases. Sure. Yeah.
So super interesting. So what do I think the working group is going to come back with? I don't think they'll opine on this question. I think they'll basically direct or recommend that the SEC look into all the above. But I think they might say that Congress should consider creating stablecoin legislation that would limit issuance of stablecoins to banks or bank regulated. So basically,
which is what the Stable Act wanted to do, right?
Which is what the Stable Act wanted to do. Yeah. So punting on, opining on that middle and just saying we're just going to carve it out, just because we think it's a thing that's important for some reason, and I'm sure they'll express why, and just saying this should be treated differently. But that's going to be. I don't see how the OCC, for example, could just do that. I think it would have to. It would be up to Congress, I think. And
it's funny.
Yeah,
it's funny because, I mean, for one thing, it's so funny because the judicial standards for whether something's a security are all, court based.
Yep.
So the executive branch actually doesn't have the power to come out and say these are securities and these aren't. They just have the power to bring cases and force judges to then make holdings and hope that the judges say, we're going to read Reeves this way and say that it's not a security if a bank issues it. It is a security if it's not issued by a bank. And that would de facto lead to a world where you have to be a bank to issue a stablecoin, because
Right.
stablecoins don't really
Yeah.
work if they are securities, because then
Right.
they can't trade on anything except the NASDAQ or the New York Stock Exchange. And I mean, maybe. Actually, one interesting question is whether a decentralized stablecoin could work even if it was classified as a security. Maybe, actually, because you're allowed to transfer shares of stock
Yeah.
person to person. And in theory, you could use a share of stock as currency if other people accepted it, in payment for things. And I don't think you run into like the need for a transfer agent or other things unless it's certain specific stock, equities transactions that require transfer agents, like from initial offerings to the public to, these sorts of things. So I think you could get away with it. Granted, then there'd be the question of like, if it is a security, who issued it? And you'd be like, a DAO, and you'd be like, no. Anyway, yeah.
So, yeah. So, what I was going to say is just that Congress these days doesn't seem able to accomplish much.
Yeah.
And so, there's a
except during the make or break moments of
no, but
infrastructure
even
spending, and
then,
even not even then, yeah.
stay tuned for our next episode. We'll probably talk about the infrastructure bill, and the punchline is these things are frozen in amber for the moment, and we may not.
You might say they are graven in stone, which is also a quote from the Reeves case.
Very good, Peter. Anyhow, so there you have it. That's kind of how I think that's kind of the state of the world of regulation. And then kind of maybe to segue to systemic risk, an open question for me is why we haven't seen enforcement actions related to that first category we talked about, where it is seemingly pretty likely.
Yeah, unregulated entities issuing it, and therefore it's probably a security.
And we just haven't seen the kind of regulatory enforcement that you would expect, but maybe that'll change. Maybe, the working group report is a necessary first step for some reason. But one reason that comes to mind about maybe why we haven't seen that kind of enforcement is because these things maybe didn't attract the attention of enforcement until they were too big to fail, one might say. And so with systemic risk, and a lot of the conversation around systemic risk and stablecoins has been theoretical, in that when Facebook and friends proposed the initial Libra,
now Diem
stablecoin, there was a lot there that raised the.
There was a lot of like back of the envelope calculations, like how many people use WhatsApp or Facebook Messenger, and if each one of them had just $10, it'd be bigger than the entire monetary supply, or something like that.
Yeah. So I was going to say that aside from a lot of other things, like it was going to be backed by a basket of foreign currencies and securities, as among many other things that raised the hackles of people in government. It was the scale, right? They're like, oh my God, if they turn this on, and I think folks in government assume that if Facebook turns something on, all of its users will immediately be using it. And
just like Facebook Pay. I use Facebook Pay all the time. I paid you, Jerry.
And Facebook has like 8 billion users or whatever, like some crazy amount. I think 8 billion is the population of the earth, so that wouldn't be right.
Yes.
But some crazy number that, as you say, would potentially threaten the monetary sovereignty of states and could present all kinds of systemic risk if it was to fail, blah, blah, blah. So there's always been that theoretical risk, but there's sort of a more pragmatic systemic risk that people talk about when they talk about stablecoins. And it's simply that if too many people try to redeem at the same time, right, there's a run on the stablecoin, then the issuer could have to liquidate its assets at a loss. And if there's enough losses, that could basically cascade into the debt market.
No,
right?
There's a run on the bank.
Yeah,
that's my
very good. So I mean,
Mr. Potter. Mr. Potter. Sorry.
Tell me what you think about this. So, the way I think about this is stablecoins are issued by bank-regulated entities like, state, trust, et cetera. They shouldn't pose this kind of risk because they're already they're already supervised and regulated like banks are, basically, right? So they shouldn't pose this kind of risk.
I mean, I'm a babe in the
me too.
woods or whatever with respect to traditional financial regulation, and I know that there are differing opinions here. Like Rohan, who we've had on tangents before, would say no. Everything should just be done through fully federally regulated. Like, is he even in favor of state banking? I'm not sure.
Yeah.
And he's probably not in favor of state money transmission licensing entities doing a lot of things, or even necessarily trusts.
Sure.
I don't know. Yeah, but
you
could be good reasons for that. I'm not an expert in that world.
No, but what I'm saying is, one might think that we don't have enough. Your risk tolerance might not be, might be so low that you think we, should just have the strictest regulation possible. But that's not what I'm saying. I'm not talking about how much regulation. I'm saying that the issue of systemic risk is one of the things that bank regulation is meant to address.
Yes. Now, whether it does it well, I don't know.
Exactly.
There is a massive shadow banking situation.
Sure. But my point being, we have a government for a reason. It's to address these kinds of risks. Presumably, they're doing it to the best of their abilities.
I just know you wanted me to agree with you, so I'm not.
You won't. Okay. So look, state bank issued, stable coins, I think, shouldn't pose this kind of risk, or at least the risk should already be mitigated.
Yeah.
Stable coins issued by money transmission licensed entities could pose this type of risk, I can imagine.
So I actually have one thought on that. So to go back to that, we've got 54 different states and territories with different permissible investment standards.
Yep.
One thing I've always wanted to know, and I don't think I've ever seen anyone at any of the exchanges comment on this, is whose permissible investment requirements are you following for which of your customers? And it seems insane to me that if you're issuing USDC or something like that, when a customer comes to you from Alaska, you're saying, oh, good, we can put this in those funds. Whereas when a customer comes to you from Texas, you can say, we can put this in only these funds.
Shouldn't be difficult to do with computers.
Maybe, but at the same time, it's just a big pooled account, right? So I suspect
it's lowest common denominator.
No, it's the strictest because you have to obey the rules.
Yeah.
It would actually be. I think Texas might have one of the strictest permissible investment requirements, and so presumably all of that money you're holding.
I don't think so, Peter, because that would leave a lot of money on the table. I can imagine that maybe if you don't want to do 54 different pools, you could at least do like 3 or 4 baskets of groupings of risk.
Here's the weird thing, though. The person you issue to isn't the person you're going to redeem from.
Oh my God!
What if the person you're redeeming from is in a different state than the person you issued to?
Yeah.
And what about the person in between who just is an Ethereum address?
Yeah.
What if they're located in a state with stricter requirements, and the money you're now technically holding for them because they're holding the note now should be in these other accounts? This is crazy. I don't know. It's crazy.
That's interesting. I've not thought about that.
As a lawyer, and I'm not a practicing attorney, but as a lawyer for a company, I'd probably be ignored because I'm telling them to leave profits on the table, but I'd probably say, you got to take a conservative approach here and keep your money in the most conservative basket of permissible investments of all of the possible baskets that the different state regulators offer, because you don't know where your customer is all the time.
That's interesting.
I don't
know. So anyhow, it seems to me that, stablecoin issued by a state money transmission licensed entity could pose the kind of systemic risk that we're talking about here. But then so does PayPal and Apple Pay and Google Pay. We're back to that. So
right. Although at PayPal, the person who's redeeming from you is the same person you issued to. So you could actually very easily exploit the different risk profiles of the different permissible investment requirements.
Yes. But we're talking here about systemic risk.
I'm just making it complicated.
You're just making it. Yeah. Okay. So anyhow, and stable coins that are basically issued by unlicensed or unchartered organizations, they could pose this kind of risk But
What do you
again,
think?
this seems like an enforcement problem, not a regulatory problem. Why are you laughing?
Because I asked you which ones.
Oh, very
Doesn't
good.
want to say. Yeah, an enforcement problem. You certainly don't need new law. I think you'd have, like, if you were a district attorney or something, and you were like, I want to bring this case, and then you talk to some other lawyer friends, and they were like, man, the case law and whether it's a security or not is pretty hard to figure out. They're not going to say that. Actually, they're going to say, actually, yeah, take this case. This is going to be a slam dunk, and it'll be great. Lots of people want this to happen, and you could probably get them on any money laundering stuff too. Maybe, so it's weird that this case hasn't popped up. I don't know. It's also hard to do investigations that are overseas, and
Yeah. But my point, but again, within the context of systemic risk, if there's systemic risk here, it's not because we haven't had the regulatory frameworks to apply to have prevented the systemic risk. It's because there's been no enforcement. It's so weird, right? And so,
well,
yeah.
Just to be contrary again, we
Don't let me
don't
stop you.
we don't usually. No, actually, you're right. Because I was going to say, like we often think of systemic risk in the insurance regulation space, insurance products, and in the banking regulation space of like minimum capital controls to make sure that we don't end up with bank bankruptcies, and Glass-Steagall, the idea that we should be segregating, retail deposits from, high risk investment activities. We don't usually think of financial stability risks coming from the securities world because of a sudden huge ballooning of unregistered securities.
Right.
I don't think that's ever happened, except back when it happened in the 1930s in the in the penny stock boom that caused
And this
the
is why
Great
we have
Depression, arguably caused the Great Depression,
Yeah.
and that also caused the securities laws to come around. I could be wrong about that. I'm probably wrong about that because I don't actually but I don't know. So maybe there's like not a regulator out there who is thinking about systemic risk as something that would require a lawsuit against someone for issuing an unregistered security. They're thinking like, are the banks adequately capitalized? They're thinking all these other things. And so it's not that someone's been asleep at the switch. It's like they didn't know this was the switch. They were watching some other switch and they're like, oh crap, there's switches everywhere. And if anything, that is the case for there being real systemic risk here, because it always comes from corners of the economy where you didn't expect there to be certain activities happening at a certain scale.
Totally. And I don't want to be misinterpreted. I'm not trying to assign blame here about people being asleep at the switch or anything like that. I'm just pointing out that
we don't need new laws.
We don't need new laws, and it's not a failure of of regulation. There's no gap that needs to be filled. It's simply that this thing went under the radar, unseen by regulators who could have applied existing regulation. And so now we're in a weird spot where, okay, so what does the President's Working Group recommend? Because typically you would say, okay, FSOC, analyze these particular entities or this type of function, and if it's systemically risky, designate it as such. And then if it's designated as such, it's going to come under all kinds of extra scrutiny, extra regulation, extra obligations. But here, what are you going to do? Designate a completely unregulated, non-compliant entity that by all
why do that when you
the SEC is probably going to enforce against?
Why do that when you should just have someone enforce the existing law against them? Yeah.
So I'm not sure. I have no doubt that the FSOC will be there'll be a recommendation that the FSOC will look into this, but I'm not sure who the FSOC would choose to designate. It just makes no sense. So
in a way, they could designate the SEC, at which point they're like, wait, how do we do that? Oh, right, we just enforce. I don't know. Yeah.
So anyhow, that
wasn't it nice when Congress made laws?
Peter, so naive.
And the courts enforced them.
Interpreted them. So yeah, so that's where we are. Is there anything else about systemic risk you can think of?
I mean, I think it's worth pointing out that this is possibly not very dire at all. How big is it? It's still not that big, right?
It's pretty big.
How intertangled with the rest of the financial world is it? Or is it mostly just like
It depends. And I think
arbitrage
actually
between big Bitcoin exchanges where most of the volume is, or capital flight out of China or things like that?
it depends. Part of the problem is that we don't know, right?
Mhm.
So we don't know in many cases what is the debt that these firms are holding. And so that opacity creates some of the fear of systemic risk. But then also, it may not be risk to the traditional financial system. It might be risk to the cryptocurrency system, which is increasingly entangled with the traditional financial system. So, anyhow,
I mean,
that's all I had.
we've had folks at the Fed say that they don't see stable coins as a systemic risk, not
Yeah,
currently.
that's true.
And those are presumably smart macroeconomists who look into these questions of scale and entanglement.
Yeah.
Or maybe, but at the same time, maybe they're just writing it off because it's
not that big.
It's I don't know.
So how would you summarize all of this? Like, I think there's a lot of angst around the imminent release of this report and all of the sort of comments that Gary Gensler has been making around the report and around stablecoins. But it seems to me like, I don't know, this is all pretty straightforward. Some things that are operating in ways that seem to be outside the law are clearly, over here. Other things that are super heavy duty regulated, clearly probably going to be fine. In between, you've got a good open question of law, but there are many ways to address it. And actually, one way to address it, so USDC, I think, is the biggest state money transmitter issued stablecoin. If I'm not mistaken, I thought I read that they are pursuing a New York trust charter to just remove any doubt. So that's
maybe because their lawyers have done a similar analysis as we just did.
Yeah. But
for extra safety margin, here.
And we're always hopeful that the OCC will grant more. So I think what could come out to address that middle area isn't end of the worldish, right? And then the systemic risk. Look, I just think there's one big problem out there, and it just needs to get addressed, and that's it.
Yeah. On the other hand,
yeah,
we're no stranger to there being like several overlapping regimes governing this stuff.
Yes.
And sometimes that's fine, and sometimes it just doesn't make sense, quite frankly. And I suspect that part of the reason that happens is that like policymaking is kind of a one-way ratchet, and just because you could address something using existing laws doesn't mean you don't want to just make some new policy. So you could imagine like, Peter and Jerry presented a very reasonable case for how you address the really risky stuff, securities law enforcement. But actually, let's just address it in a completely different way that creates a whole new regime that everyone has to follow. And by the way, it also governs cryptocurrencies and other things because we're treating all this stuff as a monolith.
And I'll tell you, if I was, maybe I shouldn't say this, but if I was somebody who wanted to make the case for why we needed stablecoin specific regulation that was different from the kind that we apply to PayPal and the rest, I would anchor myself in anti-money laundering and maybe even tax evasion, and say we need a comprehensive
law. And I mean, look at the
and that is one, and that is different, right? So that is one place where the distinction between closed loop and open loop, quote unquote, on each does
totally come
into play. So great, we just handed a great idea. All right, that's all I have.
Yep.
Good.
Was it graven in stone or graven in stone?
I don't know. But let me say this. If you've listened this far, congratulations. We will send you a NFT that
of Niraj's face.
Attests that you can present as attestation of your completion of this course.
Yeah. And
but also let us know. shoot us a tweet or something and let us know whether we should keep doing these, if this is interesting to you.
Yeah. Subscribe,
subscribe,
ring that bell.
smash the like button.
Good.
Hit the bell. Yeah. Rate and review on iTunes and all that. All right. See you next time, Peter.
Take care, Jerry.